The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning.
No, they didn't know that what she saw was real or not real because they weren't there, Ms. Jennings. So they don't know. The attitude really needs to go.
And I don't need the well, Your Honor, we know it wasn't wrong because the next day we can just, okay, ma'am. All right, I got it. Can we just let's keep going.
Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings. I think we can all agree, the way this case ended has been full of disappointments. For those of us who have been following since the beginning, it's hard not to feel let down by how little we actually got to see play out in court. No real trial, no full airing of the evidence, and no real chance to watch the defense challenge the state's claims head on. I think one of the biggest disappointments is that we'll never get to see Ashley Jennings try to argue this case in front of a jury. Because if this Franks hearing is any indication, that would have been something to behold. In a recent video, we revisited Ann Taylor's arguments during the Franks hearing. I wanted to look at it again because it gave us one of the clearest overviews of the defense's case, not just motion by motion, but a bigger picture view. And watching it with the benefit of everything we've learned since Bryan Kohberger's guilty plea gave us a lot of new context. But that was just one side of the story. So in today's video, we're going to look at the state's argument in that same hearing, presented by Ashley Jennings. And just like before, I think it's worth watching this again in light of the new information that has come out since then. Because honestly, with every new record, every new document, and every new video that gets released, the state's case seems even weaker than we ever imagined. Which honestly leaves me even more baffled about how we wound up where we are right now, with Bryan Kohberger sitting in prison and having taken a guilty plea, and it doesn't seem like the state had much of a case against him to begin with. So let's go back into that hearing and listen to Ashley Jennings argue for the state, this time in light of the new information and context that we've gained since then. Because when you line it all up, the picture that emerges isn't one of a strong case. It's one of a case that looks shakier and shakier the more you examine it. To spare everyone from having to listen to Ashley Jennings drone on, I have sped up the audio in this. I've also added in a little bit of commentary from Andrea Burkhart and Emily Baker, so that we have their insights and a little bit of their humor mixed in.
For each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
what do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think
That's an interesting hypothetical. Did he choose that deliberately? Or is it really just hypothetically it was the cast expert who lied in the exhibit? She seemed to establish in her presentation and did that, yeah, probably the cast person, maybe, because that was the change in the time for when the phone stopped reporting to the network. Because if they reported the actual time and looked at the handoffs, the transfers, it would show his direction was not in the way that they were alleging his direction of travel was. So it kind of sounds like he didn't randomly choose this hypothetical and he's buying in that, yeah, the cast expert probably materially lied. What do I do with that?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
And so her excuse is that they can use all of the facts in the Exhibit A, but only if the person, and all of those facts are sourced to all of these different law enforcement officers, and they only need to be signed off on by the detective, the one who is applying for the warrant, because they have the fellow officer rule, right? The knowledge of all of the other officers is imputed to the one that's asking for the search warrant. But when that goes the other way around, and one of those officers and that information, they have knowledge that it's false, that doesn't get imputed to the detective, seems to be her argument. I don't see that being right.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response,
Yeah, but it cuts both ways. You don't get to impute only the good knowledge and not the bad knowledge.
as discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references.
Whether they conducted a joint investigation has absolutely nothing to do with whether there should be a Franks hearing. So I'm hoping that in the interest of fairness, we'll start to see maybe some repetition of the body language from Judge Hippler, maybe some of the helping to guide her with where she really should be arguing, because nobody's saying there needs to be a Franks hearing because they had a group investigation. It's about the knowledge being imputed or not.
Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding cast. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the cast work.
Did you mean AT&T?
Yes. they didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by Balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion.
What specifically?
That there are 3 towers.
I believe I referenced it in my response.
Yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant.
So she didn't identify him. I would say that's pretty important when you relied on her bushy eyebrows to say that it's him. That is kind of important.
Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
Great question. Why were these ones even included? What do they have to do with PC? The bushy eyebrows, I understand why that one was included. But the rest of the statements about thought she heard something and the person said something, what was the relevance of that? I'm interested in this answer.
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place?
Both.
So it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time.
So that kind of gets undermined when you're saying that's Bryan Kohberger when she looks at a photo of Bryan Kohberger and says, I can't say that's him.
That corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
So when the PC affidavit is reporting that she's saying heard playing with the dog, heard something being said, etc. Did Miss Jennings just tell me that DM was texting those things to somebody as they were happening? And why would she be doing that if they were just things she didn't know that they were, significant for any reason? Because the PC affidavit certainly wasn't suggesting DM knew her roommates were being murdered and was giving a blow by blow. But if that isn't what happened, then why would any of that stuff be significant enough for her to be texting about it?
And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during their interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning.
No, they didn't know that what she saw was real or not real because they weren't there, Ms. Jennings. So they don't know. The attitude really needs to go.
And I don't need well, Your Honor, we know it wasn't wrong because the next day we can just, okay, ma'am. All right, I got it. Can we just let's keep going?
Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Bridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene.
Do some quick math in my head there, because that doesn't seem quite right to me. That seems like 0.3 miles. The car is going, oh, let's give it the benefit of the doubt and saying it's going 20 miles an hour in a residential neighborhood. 60 miles an hour is 1 mile a minute. 20 is 3 times that. It would be 1 mile. Look at that, in 3 minutes. This is only 0.3 miles. 3 times too long.
They say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
So additional information. Additional information that they had that wasn't submitted with the warrant.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel.
Defendant speculation about the route of travel, that's pretty rich. That's pretty rich.
And their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or a sufficient proffer for you to do that. Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that well, I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to. Really, the IGG has been discussed extensively. I think the only real Frank's issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Frank's hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing. Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of this shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by the
Correct, with
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's
If
material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not.
Well, because you undertook to represent to the court how you think he got there. And having done that, if you knew he did not and could not have gone that way, you didn't have to do it in the first place, but you did. And so you misrepresented it. That's the problem.
It's a leap for me. Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. it wasn't, but let's say it was, well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory.
It's definitely exculpatory. It's just, is it harmless?
The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Briefly.